fantastic pop-up podcast room in Bishop Stortford. This is our first episode, so very excited. My name is Michelle from SFB Consulting. We're a human resources consultancy company.
And I'm Ola from Tees Law, and I specialise in employment law.
So many employment law updates coming up.
There are. It's we're seeing a massive employment law reform, basically, from now till 2027, I believe. There's going to be a lot of changes.
So we've already had sexual harassment.
Yes, we have.
That came in October.
In October last year.
I still think a lot of companies don't know.
No. But I am seeing a massive increase in the number of cases. Well, you only have to see with the media, with the whole Greg Wallace and there are a number of other cases. They are becoming more high profile, and I am seeing an uptake in people making complaints about sexual harassment. I don't know whether that's because of the law or they are becoming more emboldened. Well, emboldened is not the right word, but more confident, let's say, to bring those kind of.
I think all of these public cases have meant that people do feel that they're being heard now. I certainly think that a lot of companies are worried about this now, but I don't think they understand the enormity of what their responsibilities are now. Yeah. But they're certainly worried to the point where I've heard a lot of companies not having Christmas parties now and things like that.
Really?
Yes. Yeah. Decided not to do it. On
the basis of the fact that they think that it will go down. It will go down.
Yeah.
So that is wow.
Let's think about some of the other things that are coming in. I know that, as you said, there's a lot of change scheduled over the next couple of years, but I don't think, like, for example, there's the day one employment rights. Yeah.
So day one and flexible working, of course. So that will be from the day one of when you start your new job, you will have the right not to be unfairly dismissed. I think a lot of people get that wrong in that they think, because we both know at the moment the time that you need to be employed in order to pursue an unfair dismissal claim is 2 years.
Of course.
And what the government have said is it will be day one, you have the right not to be unfairly dismissed, but that means that the employer needs to follow a correct procedure in order to dismiss somebody. So it's not saying that they would be able to pursue an unfair dismissal claim, it's just saying that the employer needs to have a genuine reason, which I would hope that
you would do anyway.
Yeah,
absolutely. Presumably probation.
Yes,
we're gonna.
Yeah, well, that's going to have more of an impact on. Well, at the moment, it's not a statutory provision, is it?
No.
Probation. You can have it. You can have it. You don't have to have it. But if you have a decent probation system in place, then you can monitor people's performance or their conduct or whatever else, and if they're suitable for the job. And let's not forget, it is a two-way process.
Of course.
The employee can decide, not really.
For me.
Yeah.
Exactly.
Yeah. Not down with it.
And in terms of flexible working, what changes are we going to see?
Well, you don't have to have that 26-week period to qualify anymore. You have it from day one.
Yeah.
But the business has the right to deny the request if it's not suitable, if there aren't any business reasons.
I think often with flexible working, and we certainly hear it a lot, where I don't want to let them work flexibly because that's going to set a precedent. And what they don't understand is that's not the case.
No.
It's really on a first come, first served basis.
Yeah,
you
and
have
also
to look at the business.
Absolutely right. Yeah. It has to be right for the business, and you don't. If it's not right for the business, then you don't have to. And you've got the business reasons to deny it. Then let's just don't do it.
And also sometimes the reasons for denying it you know, it's based on it's a personal thing rather than a business business thing. So it's more of an annoyance than
exactly. Yeah, you can get, you know, there's biases and everything, and with some of the cases that I see, you do get, I just don't want to do it because that person's really annoying.
Yeah.
It's not really the reason not to give it to them.
Not a good reason.
No, not at all. But, you know, if you've got a genuine business reason that you're not going to...
And there's a list of genuine reasons.
There are a list of, yes, that's right.
It's not difficult.
No, it's really not. But just make sure you do, you know, do your homework. It's not just a blanket no. Apply it to the...
And also, I think companies don't realise that there's a time scale, you know, from start to finish.
Yeah, there is.
Including appeal,
then
this all has to be done and dusted.
It has to be done within that time period, and if it does, and if you don't, then that individual can make a complaint or raise a grievance or whatever, or take it even to the employment tribunal if they wanted to. So it's important to review whatever flexible working policy you have in place so that it complies with the current law.
And again, with everything, it's about education, isn't it? Making sure that your managers understand the policies that you have in place. Yeah. I mean, there's so many policies, things that they have to understand, but it's really important that they keep on top of that.
Oh, of course, and it's not about just having them. You know, you need to live those policies. There's no point in having, you know, just playing it lip service. Yeah, I've got that in place because just this.
That ticks that box.
Exactly. Yeah, don't do that.
Yeah.
Make sure that you know it inside out. Apply your business to what you actually have in place, because you know, there's nothing worse than an employee come up to you and saying, I want to work flexibly. No, you can't. Hey, but we've got a flexible working policy. Oh yeah, that old thing, you know.
I don't even know what it is.
No, don't. Yeah, exactly. So there's no point
taking
in
up
that.
dust on the bookshelf.
That's it. That's it.
What else can we expect to see?
There is going to be a ban on NDAs, so non-disclosure agreements for cases of sexual harassment.
Again, it brings in all of the changes in sexual harassment law.
Yeah. I think that one's going to be really tricky, because I'm not saying that employers should have, restrictions on people to disclose whether they have been, sexually harassed, but there's also, in settlement agreements, for example. A key term of a settlement agreement is confidentiality. And often employees will leave if they feel that they've been harassed or whatever, How will that work in practice, really? I'm not sure. I mean, and it remains to be seen.
Yeah, exactly. When is there a time scale?
I think that's 2027, I think. I'm not sure, don't hold me to that. but yeah, it's not now. But it will, and when it comes in, I think it will make a massive splash. I think people will be really, really scared about what that means for them and their businesses. It won't apply to NDAs across the board, so they will still be enforceable. It's just in relation to that sexual harassment or discrimination cases. So yeah, so that's that. We've got the
fire and rehire.
Oh, that was stemmed off the P&O issue.
Yes.
Yeah, and there was I think there was a Tesco case as well. So yeah, I think it's again, I'm not sure that really is going to make a massive impact. I'm not sure of it yet, because essentially it's, you at the moment what you do is you consult with your employees if you want to make changes to the employment contract. If they don't agree,
so long as the business case is strong enough,
that's it. Then you fire
and rehire.
Yeah, so I think it's just that, and it's not making it so that, you know, as long as you've got the business case and you've got everything documented, you've got a paper trail.
And then you have to notify ACAS.
Yeah.
It's the extra step in between, so they can let you know if it's okay or not.
Yeah, exactly.
Which invariably it probably won't be.
Well, I mean, going off subject slightly here, I'm worried about how ACAS are going to deal with this, because at the moment I'm seeing a lot of delay.
Right. It's going to add more delay.
Yeah, I mean, you know, I think they're going to need to employ a lot more people, because I'm applying for ACAS early conciliation with my tribunal cases, and then getting...
What's the time scale on that?
Well, we should be allocated a conciliator within a couple of days, but I'm getting it like the week of the early conciliation is expiring, and then I'll get an early conciliation certificate 2 days after.
How about, sorry, we're
going off again.
Tribunal times, so to get from application to whether it be...
I think we're still seeing a massive backlog from COVID times, unfortunately.
Really?
Yeah. Whereas before, for simple cases, so an unlawful deductions case, we would see it listed within 6 to 12 months. We're seeing 12 to 18.
Right, yeah.
And also the time that the hearings are listed for are increasing.
Right.
Because invariably you'll get a judge that wants to have a reading day on the first day, so that will be reading all of the documents. So you'll go to the tribunal in the morning, the judge will say with the panel, yep, this is what we're going to do, these are the steps we're going to take, go away, we're going to read, come back tomorrow at 2 o'clock.
Yeah.
And so that will take a lot of time. But yeah, the tribunal cases are increasing. And they're only going to increase more now with the new law coming in as it
And again, I guess
through.
that's steadily started to increase from, you know,
Already.
when they abolished the
fees. That's it.
Things.
That's it. Yeah, that's it. Well, no, and it swings and roundabouts as to whether fees were good or not. But you know, they said it restricted access to justice, and I did see that. But there was a reason they put them in, and I think I don't know whether they're going to redo it or not. I'm not sure.
So having taken us slightly off piste, trying to bring us back in again.
Yeah.
So the bereavement.
Oh, the parental.
Yes.
Yeah, I think. I think that's a welcome addition. That's come in this year.
And then, of course, there's the bereavement, right?
Yes, of course, and there's also the miscarriage pay that you get. So it's basically the same as maternity, and you know, I think that's a welcome addition. You know, not least because from personal experience, if I may, you know, I had a miscarriage, a very early miscarriage, about 13 years ago. I went on to have my son afterwards, so that was great. But there was a stigma attached to it because, you know, you don't have the full pregnancy. I mean, thankfully for me, it was very early stages. But you know, there are some people that
are expected to get on. You know,
and it's just you don't really feel that way. No, you don't want to do that. No. So I think that's really
and it's
really
so common. I had the same.
Did you?
Yeah. So I had 2 miscarriages, and you know, everyone just kind of
get on with it.
Carry on.
Yeah.
And also, you don't really want to talk about it, do you?
No.
But I think it's definitely a very welcome.
Yeah, because you go through a range of emotions at the time, and working isn't necessarily the first thing you want to do.
Yeah.
It wasn't for me.
No, I agree.
So it's I think that's great. I think it's great, and the parental bereavement one as well. You know, goes without saying, you should be allowed that time off, and you should be paid for it. You know, it's not rocket science.
And then, of course, we have the redundancy changes.
Yeah, we're seeing a lot of redundancies at the moment, unfortunately, and I think that's a symptom of potentially the national insurance contributions hike.
Absolutely.
And businesses not really knowing what's going on. I mean, obviously there are different things in the economy that are, you know, and the world at the moment that are affecting businesses. But redundancy is definitely something we're seeing an increase in at the moment, and getting the process right is so important, particularly if you're dealing with large numbers of people, because, you know, not only is there the legal element, there's also the human element.
Exactly.
And, you know, some of these people have been working for these companies for a long time.
And of course you're thinking about those who are at risk, but not only that, those who are left behind.
Yes, survivor's guilt.
Yes, exactly.
Yeah.
And how you deal with the process says a lot.
It does, as a business. And, you know, in this day and age, there's little things that matter more than anything else.
I agree.
So, yeah, it's just about getting that process right and making sure you check in with your employees, making sure they're okay.
And making sure you have good advice.
Yes, that is the most important thing.
Of course. So, we have a webinar.
We do.
On the 23rd of September.
That's correct.
And
yes.
we're going to go into a lot more detail about all of these changes.
Yeah, we will do. So you can sign up on LinkedIn on either of our profiles, I believe. Yeah, come along.
It's a free webinar.
It's free, which is...
And we'll be there.
What more would you like? Yeah. Yeah, so come along.
Be there or be square.
Exactly.
So if you want a step-by-step breakdown of what's changing and how to prepare, then join us for a webinar later this month. It's all about all of the changes throughout 26, 27, and that's on the 23rd of September, and we'll be there.
We will be there.